Hello and welcome to a company law presentation. My name is Amal Jolly and today I will be taking you through a presentation of a detailed analysis of the current legal position. And today I'll be navigating through my mouse and I hope to present and dive deep into this interesting evolution of the concept of the separate legal entity in the limited amount of time we got by covering legal precedents, significances and references. Every company, when incorporated, has its own separate legal personality known as the corporate will. This fundamental concept is confirmed by the House of Lords case of Solomon and Solomon, which creates a separate personality for company and its shareholders, thus creating a kind of risk of abuse, and this risk is in turn transferred to the company. The courts, in the interest of justice, have sought to prevent such abuses by simply piercing through this corporate will for the party to be held responsible. The conditions and circumstances under which the piercing of the corporate will has evolved through a series of company and tort law cases, and we'll be looking into this to determine the current legal position when the court will pierce the will. Looking at the company law cases, we will go through the four significant cases which demonstrated the evolving line of rulings. In Gilford and Horne, the Court of Appeal found the company was simply set up as a facade to avoid contractual obligations. Moving on to DHN and food distributors, Lord Denning outlined single economic unit where the court examined overall business operation as a single economic unit rather than one single in a strictest form. Next, we see in Adam and Cave, which plays an important role as the court declined to pierce, in this case, the corporate will and recognized the legitimate use, which gave rise to Law Justice 3 independent circumstances where veil can be pierced. Moving on to a recent pivotal case in Pest and Petrodol, we see the Supreme Court recast the veil piercing circumstances, unlike we see as seen in Adams, to two new principles and an unanimous decision. The principles are the evasion principle and secondly the concealment principle, where the veil can be pierced to simply through evasion or concealment of the duty or obligation of. Moving on to the tort line of cases, which opens up a whole new dimension, we can see a totally different view where the court pierces the veil, where the parent companies are held responsible for its subsidiaries. This is based upon not expressly but equivalent effect, where a test is done based on the duty of responsibility or care resolved. And a test is similarly done to check the involvement or intervention in the management. In the case of Connolly, we see the parent company held liable for an overseas subsidiary. The judgment says, similar to other cases, the parent company owes a certain duty of care to all of its employees. In the case of Chandler and Cape, we see Lord Justice Arden dismissed any suggestion of involvement of piercing veil, but she takes a whole new equivalent effect by application of tortious principles. We see in the recent case of Unilever and AAA, the court distinguished between the parent company's wide system of mandatory policies put in place to control its subsidiaries. It identified two new scenarios of intervention, which led to a duty of care being owed. Finally, in the case of Vedanta, the issue is whether there is sufficient level of intervention by the parent company to assume responsibility of duty of care over the subsidiary. Vedanta argues that the cases of Oknabi and Unilever, we discussed just right now, provide a general principle that a parent company could never incur a duty of care in respect to the activities. The Supreme Court rejected this and stated that there is a duty of care where there is a company-wide policy. Where it is responsible to demonstrate the UK parent company has assumed sufficient responsibility, we can assume a duty of care is automatically owed. As going back to the question, Vedanta has not driven a coach and horses through the separate legal entity. because the parent-subsidiary relationship enables the parent to take control of all of its subsidiaries, as we see in all of these cases. Everything depends to the extent to which the parent company has intervened, controlled, or advised in its subsidiaries. This does not break separate legal entity principle. Instead, it shows the harshness of the rule to hold parent companies accountable for their action, which prevents them from gaining unconscionable advantage as a result. As a result of this general principle of limited liability that comes from the corporate will. Now we can conclude by saying the courts will pierce based on the cases on equivalent decision based on evasion, concealment, assumption of responsibility, from piercing the veil to remedies in equity and tort, which undermines fundamental separate legal personality and limited liability. Thank you.